A woman stands before a judge, ready to accept a deal that would let her walk away with probation. On paper, it looks simple: a guilty plea, a fine, some restitution, and she moves on with her life. But underneath that deal is a criminal history so long, the judge literally runs out of fingers counting it. This is the story of Crystal Bogan, a woman charged with theft of property, a state jail felony, after allegedly walking away with $10,000 that didn't belong to her. The plea deal on the table: 4 years of deferred probation, a $1,000 fine, and restitution to pay the victim back. Sounds fair, right? Except there's a catch. When the judge starts flipping through the pre-sentence report, she doesn't find a clean slate. She finds pages, plural, of prior offenses: forgery, theft, aggravated theft, possession of criminal tools, smuggling of persons for pecuniary benefit, multiple states, multiple probations. And she's still on probation right now for 5 separate cases in a different county entirely. So here's the question hanging over this entire hearing: how many chances does one person get before the system says enough? Stick around, because what starts as a routine plea hearing turns into a full-blown standoff, complete with a rejected deal, a courtroom outburst, and a bond that gets slapped up in real time. Let's break down exactly how this unraveled, moment by moment.
Board entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes.
And any additions or corrections or?
There's a lot of history, you understand, but discussed with counsel also restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. Okay,
The deferred one.
another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, I don't think that's a big fee, I believe. I don't think that.
Well, it says 500.
That's what just happened here. This is a masterclass in why the fine print in a plea deal matters. The original agreement said restitution of $9,400. But when the judge actually does the math from the pre-sentence report, the real number is $10,000. A $600 discrepancy made up of a $500 ATM withdrawal and a $100 Cash App transaction that weren't part of the original figure. Why does this matter? Because in a plea deal, every dollar of restitution is legally binding. If the paperwork undercounts what the victim is actually owed, the victim gets shortchanged, even if the defendant is held accountable. This is exactly the kind of detail that gets glossed over in a routine hearing, and exactly the kind of detail a sharp judge catches. And you can hear the defense trying to pin some of it on a bank fee, while the judge is essentially saying, the paperwork doesn't lie, and neither does the bank's own timeline of withdrawals. This moment is the first crack in the deal. It signals the judge isn't just going to rubber stamp this agreement. She's actually reading it. And that's going to matter a lot in the next.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay.
The only thing we knew about
That was
was 900 that was in the bank.
I wasn't aware of, Your Honor, when we did it and got the When I got the PSIs, when I was notified if I was in the cash route. But if it was a withdrawal, then that would be her responsibility joint and separately. So
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and hold on. So the probation's in Sutton County. Have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we
So,
understand.
all right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. I mean, it has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do?
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 hearings
There it is. After literally running out of fingers counting prior offences, forgery, aggravated theft, possession of criminal tools, and an active 10-year probation for smuggling of persons across 5 separate cases in another county, the judge pulls the plug. The plea agreement is rejected. Let's be clear about what this means procedurally. A plea deal is a negotiation between the defense and the state, but the judge isn't obligated to accept it. Judges have the authority to reject a plea if they believe it doesn't serve justice, especially when a defendant's history suggests probation isn't going to stick. And when you hear Bogan claim her prior cases all ran together, the judge shuts that down immediately, clarifying that concurrent sentencing doesn't erase the number of separate convictions. It just means she served them at the same time. This is the turning point of the whole hearing. A deal that looked like a formality 30 seconds earlier is now completely off the table, and the case is getting reset for 3 weeks. But as you're about to see, the fallout doesn't stop with the ruling. It gets a lot messier.
Okay, you have lots of them that were at the same time for different offenses.
I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, theft, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all,
It's one.
it doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
It don't matter. My life's going on.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back.
I heard bullshit.
Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too?
Well, maybe you shouldn't cuss at your lawyer, maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're gonna make it worse. You're just gonna make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. Let's see, can you, all right, I'm going to set your bond at $25,000.
So let's recap exactly what went down. Crystal Bogan came into that courtroom with a plea deal already negotiated. 4 years of deferred probation, a fine, and restitution for a theft of property charge. But the moment the judge dug into the pre-sentence report, 2 things blew the deal apart. The restitution figures didn't add up, and Bogan's criminal history turned out to be pages long, spanning multiple states, multiple felonies, and an active 10-year probation she was already serving in a different county. Faced with all of that, the judge did something a lot of people don't realize is even possible. She rejected the plea deal entirely and reset the case for 3 weeks. And when Bogan reacted with an outburst in the courtroom, the consequences escalated immediately. The judge found her bond insufficient and raised it to $25,000 on the spot. This case is a real look at how much power a judge holds in a plea hearing. It's not just a formality, it's a genuine checkpoint where the whole deal can fall apart if the numbers don't match or the history doesn't support leniency. And it's a reminder that how you conduct yourself in that courtroom can carry real, immediate consequences.